So now we're going to be talking about the Federal Rules of Evidence, Rule 407, which talks about the subsequent remedial measures, where pretty much the way to think about this rule is when you have something that goes wrong, you're not allowed to bring in, it's inadmissible to prove negligence or culpable conduct or a defect or a warning based off of a person's later measures that they take to change that thing that went wrong. However, you are allowed to bring this in for a different purpose, such as impeachment. We're going to talk a little bit more about that in a later rule. Or if there's a dispute of ownership, control, or the feasibility of precautionary measures. The prime example that I want you guys to think about with Rule 407 is in TOR, we had a case where they wanted to show that the hospital changed the heparin policy and they wanted to bring that in to prove negligence, and they're not allowed to do that. However, you are allowed to bring it in for the feasibility of precautionary measures only if it's in dispute. So in the case of TOR, they tried to bring it in. However, the court did not allow it in, and they took a narrow approach of the feasibility of precautionary measures, because if you take a broad approach, it sort of ruins the whole purpose of the rule of trying to keep away things that are proving negligence.